Hi guys, today we're going to talk about the difference between joint legal or legal custody and physical custody. So what is physical custody? Sole physical custody means where the child primarily resides under supervision of one parent. Sole physical custody. Joint physical custody is where the child resides, for example, when the child resides in both households and has continuous constant contact with both parents. So for joint legal custody, it is not required that the child spends exactly half of the time with one parent and then half of the time with another parent. So the visitation with joint legal custody can be different. It could be 30-70 as well. So another word for sole is primary custody. It's the same. And for joint, shared custody. So when determining custody, physical custody, it is important to pay attention to tax consequences, income tax, who can claim a child as a dependent. And typically, IRC code section 152E1 states that whoever has the greater portion of time apportioned to spend with the child can claim on federal tax return the child as a dependent. And also it is important to know about the $2,000 exemption that recently increased from $1,000 to $2,000 per qualified child. So in order, both parties can reach an agreement who can claim what year, alternating years. For example, if they have joint custody and share time equally, then they can make that agreement and they can fill out a form, IRS form 8332 and attach the tax returns. So that's, and also it is important to know for physical custody, the entitlement to public assistance. So whoever has sole physical needs to keep in mind the taxes, public assistance, and joint legal custody, physical custody doesn't mean that that parent only going to spend half of the time. So sole physical custody could mean that the other parent still gets visitation. Switching to legal custody. Sole legal custody is defined by in Family Code sections 3006, and it states who makes the primary decisions about health, education, welfare of a child. And joint legal custody is defined in Family Code section 3003. So when court decides whether or not to award joint legal custody, there is no presumption that both parents have to be sharing joint legal custody. However, the court has to consider what is in the best interest of a child. And I spoke about best interest of a child extensively in my video that is called 3044 presumption. And the court has to consider frequent continuous contact to both parents as defined in 3011, 3020 Family Code section. And it doesn't mean that the other parent doesn't have the freedom to relocate. So that's also codified in Family Code section 7501. When I tell you code section, so I assume you would Google it and then read them and get an idea get more in depth what I'm talking about. So when we consider joint legal custody, frequent continuous contact to both parents, and best interest of a child. So, and then when you fill out the petition paperwork, meaning divorce petition or custody, you have a choice to check boxes regarding joint, sole. So some parents are very focused on whether the other parent filled out a certain way and how to respond to that. these petitions, which is FL 100 or FL 200, they are designed to get a case number. They're indicating what a parent plans to ask and intentions, but they're not a set law, meaning it just, this is what I would like. It's not going to be ordered by the court because it was checked off. So in order to get an order from a judge, a parent has to file a request for order FL 300 and then state on that FL 300, check off on top the boxes, child custody, child visitation, and then in every county in the Bay Area in California, the court will send both parents to mediation in order to speak about custody. And in some counties, for example, Marin and San Mateo, it is recommending mediation county. What it means is that the mediator will prepare a recommendation, a report that in 99% of the cases the judge is going to adopt, because the mediator spends 3 hours talking to both parents and the judge only has 10-20 minutes on a short cause hearing, and both parents will give feedback whether or not they agree about any portions of this report, and then the judge will make a final decision about this report. All other counties, San Francisco, Santa Clara, actually Alameda also is recommending county, and I think I'm not missing any counties. Contra Costa are not mandatory recommending, counties, which means the mediator will not make a recommendation. I personally prefer recommending counties because it gives a solid way to know what's coming, and the mediator spends a lot of time with both parents, but it could go either way depending on how the parent is being in these mediation sessions. That's why it's so important to prepare to the mediation session as if it's the most important court hearing ever, because in recommending county it's almost like, I tell my clients, it's like prepare like as if it's a trial. You have to be super prepared with all the pictures, all the exhibits, everything you need the mediator to know to make an intelligent decision about custody and visitation. So that's all I have for today. If you have any questions, comment down below, like, subscribe. I'll see you. Bye.